CRJ 225, this is your podcast for Section 5, sexual assault, false imprisonment, and kidnapping. This is sometimes a tough topic for students, either directly or indirectly, because some of these things are experienced by many people, female, male, young, old, and it's not something that we obviously feel comfortable talking about, so it may be uncomfortable for you to talk about it or to discuss it. It may also be uncomfortable because it's something you have, as I said, experienced directly or indirectly, either yourself or someone you love or care for. And let's just clear the elephant in the room. At the time I'm recording this, we're seeing the unraveling of one of the largest sexual predator rings, whatever you want to call it, and people being arrested across the world and potentially here, hopefully here as well. If you haven't paid attention to that whole saga, there's plenty of things to be aware of. In Illinois, we don't use the term rape and we don't use the term sexual battery. And sometimes it's confusing as to why we use the term sexual assault, especially in light of the section we just finished where we revisited the first set of crimes that we've talked about in this class, assault and battery. Because we know that assault, in simple assault and simple battery, a battery is where there is actual physical touching. And then in criminal sexual assault, there is also a touching. It gets confusing. But just know that those are the terms that we use. We don't use the term rape. Rape in Illinois is criminal sexual assault. The intent was, in discarding the term rape, was to lessen the stigma attached to the crime, therefore encouraging more victims to come forward and pursue the offender in court. You've looked at the statute, I hope, and if you haven't, you need to stop and go review the statute, because what I'm going to say won't make a lot of sense unless you've done those things I've asked you to do before listening. But we find the crime of criminal sexual assault at 720 ILCS 5/11-1. And the offense is a Class 1 felony. The potential penalty is 4 to 15 years in prison. It's a non-probational offense. That means that the judge is not permitted under law to sentence an offender to probation if convicted or pleading to criminal sexual assault. So the prison sentence is mandatory. Consequently, the minimum penalty for criminal sexual assault is 4 years in prison. The crime is committed when an individual commits a penetrative sexual act against another without their consent or the ability to give consent. In other words, remember consent in our discussions of capacity and consent. Someone who doesn't have the mental capacity. That can be an older person who lacks mental capacity because of some condition related to their age. That can be an adult who has some condition, physical or mental, that causes them to lack capacity, and that is anyone younger than 18. It includes sexual acts against victims who are underage, mentally disabled, or otherwise incapable of giving consent, in addition to sexual assault. there's discussion of the threat of force, and we refer back to that recently completed review of assault and battery. And if you think to uh, the discussion about aggravating factors, when an adult has sex with a minor, it is commonly referred to as statutory rape. It is considered sexual assault because the minor cannot legally give consent. Sexual assault cases frequently involve incidents, more often than not, between people in private. And that means there are often conflicting narratives about criminal acts that complicate the prosecution. If you think to um, some of the other crimes we've discussed and the cases we've reviewed, there's often witnesses, bystanders, people who see the thing, or video, some sort of video that was able to be captured at that scene. And that's not typically the case in criminal sexual assault. As um, an aside, because if we were in a classroom, this question often comes up in this topic. Some of you are at an age where you may still have a high school boyfriend, girlfriend who you had a relationship with before graduating high school and coming to Illinois Central College. And that individual may be younger than 18. Yes, this applies. Yes, I know of cases where an individual who was older than 18 was in a relationship with another individual who was younger than 18 and in fact prosecuted and ended up on the um, the sexual offenders list. Those are unique situations. That's not the situation we're talking about. But I will tell you, if that is you, you probably need to talk to somebody and sort that out. You need to figure out what you're doing, and you need to make sure that you don't end up in that situation. Now, over the years, forensic science increased in evolving police training and the development of sex crimes units. Law and Order SVU is a television show that is specifically focused on these types of crimes, sex crimes units. These things have changed the ability to prosecute cases. ER nurses who are trained to be forensic nurses to deal specifically with sexual assault victims, to gather the physical evidence in a way that stands up in court. But sexual assault and related crimes continue to present unique problems for police, prosecutors, and defendants. And I think, again, our situation the last few years in the United States, it's now spread across the globe in this ring of Epstein, has proved that, right? Lots of documentation, but, you know, and lots of victims telling what they um, remember as happening to them, but the forensic science and some of those things is not there, and it's because it's all these years later, right? If you think of that in the terms of forensic science and the police's ability to investigate, and if you've ever watched the Law and Order SVU show, they do a great job of providing examples of what that means as far as immediately gathering that evidence. Like any crime, the longer that you let those circumstances sit, the less likely it is to have the best physical, forensic, and testimonial evidence. You remember, we have had a short discussion. If you take the CRJ 230, if you've already taken it, or you'll take it in the future, you'll know that a lot of our cases of any type are proved by circumstantial evidence, often testimony of witnesses and testimony of people, their memory, etc., and ability to retain and testify doesn't get better over time. That's not how it works for any of us. Now, criminal sexual abuse is a Class A misdemeanor, and it's a sex crime in Illinois, and criminal sexual abuse could be a felony depending on the circumstances. So again, our aggravating factors. But even if someone is prosecuted and convicted of the misdemeanor, they still register as a sex offender. As for the felony, the Class 4 felony version found under 1.50, that covers criminal sexual abuse that is committed under the force of threat or force, or the victim was unable to understand the nature of the act or to give knowing consent. Now again, these are highly specialized cases from the investigatory and legal perspective. It's an area that if you go into policing, you're going to have a significant amount of training. If you're working in other areas of the law, working for a prosecutor or defense attorney, you're going to have significant amounts of continuing legal ed. And best case scenario is that you have a crime reported early, that the evidence is gathered quickly, that it's processed properly. There's a chain of custody of that evidence, and remembering that sometimes or more often than not, the physical evidence is gathered at a hospital or medical facility, so it doesn't go directly to the police department, but eventually it would end up with the police department and then at the courts. So you have to have a chain of custody, and it can be complicated. Let's move on to false imprisonment and kidnapping. False imprisonment is a civil matter. It's not a criminal matter. But in Illinois, we have a criminal version called unlawful restraint. So false imprisonment, if you hear that term and you hear someone say that they were the victim of false imprisonment, a lot of times that comes up in like a retail theft allegation where the security officer asks the person to go to the security office at the Target or somewhere, and then if they don't feel they can leave. But that's a civil case, and we're not dealing with that. We're dealing with unlawful restraint in Illinois, and it's under 720 ILCS 5/10-3. The person commits unlawful restraint when he or she knowingly and without legal authority detains another person. It can be broken down into the following elements for a little better understanding. First, there's a detention. Unlawful restraint has to involve a detention. and it's an intentional detention, okay? You cannot commit the crime of unlawful restraint by accident. You have to intend to confine someone else. However, there's no requirement that the victim be physically placed in some sort of secure holding area, cell, etc. It's enough that the victim believes they are restrained from leaving an area for a detention to occur. Now, some of you may be signed up to take the CRJ 227 course in the summer or have taken it. And if you haven't, you should take that class because that covers all the basic police procedure issues, one of which is, arrest. When is somebody under arrest? An arrest isn't when the person is clinked up and handcuffed and stuck in the back of the paddy wagon. The arrest is when the person doesn't believe they can leave. Same with detention. It's not that the person couldn't get up and physically walk out the door. It's that they believe they can't. So, detention can result from verbal orders, from lies, from physical restraint. Violence or the threat of violence is often involved in a unlawful restraint. So that's the first element, detention. Unlawful, it has to be unlawful. The legal authority to detain another person has to be there, and if it's not, it's an unlawful restraint. Somebody with the legal authority to detain another person can't be convicted of unlawful restraint. The court will decide whether or not someone had legal authority to detain another person. Time is another element. There's no minimum time requirement for a person to be confined. So even a momentary confinement could be sufficient to form a conviction for unlawful restraint. That's not normally the case, but there is no element of time. You have to be kept in a place for 10 minutes, 15 minutes, an hour. Consent is an element. If the victim consents to the confinement, you can't unlawfully confine them. So that goes back to that whole detention issue. Do they believe they can leave? So the mall security officer or the Target security officer asked the person to follow them to the security area. They did not commit unlawful restraint if the person accompanying them did so voluntarily. And then the element of escape. The confinement of the victim must be complete, meaning the victim must not be able to leave. For instance, a person can leave a confined area by opening the door and walking away. They're not confined. However, the victim must be aware of the reasonable manner in which he or she can escape, and the victim must be capable of acting on that means of escape. If the victim believes that violence will result if he or she attempts to leave, that is enough to make the confinement complete, even if an easy escape route exists. So violence can be somebody running them down and throwing them on the ground, harming them. Unlawful restraint's a class 4 felony offense punishable by 2 to 3 years in prison and a fine of up to $25,000. And the defendant would also have a year of mandatory supervised release, formerly known as parole, after prison, and up to 30 months of probation or conditional discharge. Now, that's different than kidnapping. Under Illinois law, persons guilty of kidnapping, if he or she knowingly confines another person against their will and moves a person by force or threat of force from one place to another. Compare that to unlawful restraint, where you're taken to the security office, or you go to the security office. You don't think you can leave. Kidnapping, someone takes another person and moves them. A person can be kidnapped through fraud, through deceit, enticement, So it doesn't have to be by gunpoint or by physical action. But the perpetrator must have intended to secretly confine that individual against their will. There's different types of kidnapping. There's parental kidnapping, our Amber Alerts, right? Often deal with parents, one parent taking the child. Acquaintance kidnapping, the one we deal with most are the categories where it's a stranger kidnapping, which can be sexual predator kidnapping, human trafficking. And then we have the kidnapping for extortion or ransom. Now, in your research and your assignment, I've asked that you not deal with the parental kidnapping because that's a whole different ball of wax. The police will be involved. The police will deal with that case. There may be criminal charges. The state may be involved in the parental kidnapping, but most of the time there's some sort of issue before the family law court on the civil side of the courtroom about custody. And most of the time, those issues are sorted out over there. Assuming there's no harm to the child's not taken and hidden away. And we do see those cases, and in those cases we might see criminal charges. But most of the kidnapping cases that we're really concerned about, those stranger kidnappings, sexual predators, human traffickers, kidnapping for extortion or ransom. Now, this is going to conclude our review of crimes against persons. And as we move to the next section, we're going to start to get into the property crimes: burglary, arson, theft, robbery, receiving stolen goods. That part of the wedding cake that we've discussed, that big part of the wedding cake, the part of the wedding cake of crime that you're going to deal with most if you go into law enforcement. The things that most impact people, the largest number of crimes at the courthouse being prosecuted through the most likely the misdemeanor courtrooms. I'll close saying this. When I began this podcast, I talked about the fact that it's not uncommon that someone in a class has experienced some of the things we just discussed, either directly or indirectly. And I always offer, when we get to these types of topics where that's the case, that we have counselors available at Illinois Central College who can help you, can talk to students. They talk to students, faculty, staff. They're available to everybody because mental health is as important as physical health. They go hand in hand. And if you had trauma from something like this, or if you're experiencing something now, you need to talk to somebody and deal with that. It'll help you immensely today and tomorrow. And so you can always reach out in confidence for a referral to those resources. Likewise, the legal studies students who take a family law course get into the civil side of these things, and also abuse, neglect, and resources. And locally, we have the Center for Prevention of Abuse, which, when we have people in our community who have been subject to assault, battery, criminal sexual assault by someone in their household, doesn't have to be a spouse or partner, the center provides resources, helps with relocation, with protection, with getting away from the situation, with counseling, the whole ball of wax. And that happens to males and females. And I've seen over the years about the whole spectrum. It's a wonderful benefit and resource. Of course, they're always a little overstretched, but they do a great job. They have court advocates at the courthouse who help with orders of protection and those things. Many of our graduates have gone on to work in those court advocate positions and also to work in areas related. So keep that in mind as well. That's our Section 5 podcast. If you need me, you know where to find me.